Hello everybody, welcome to iExamB. This is Amrita, your law faculty at iExamB. In this video today we are going to discuss the previous year questions from previous year papers SEBI Grade A Legal Officer Examination, that is from the year 2020 and 2022. We will be discussing it topic wise. I have started a series of these questions. This is the first video of the series. I will be picking up law of contracts unit in this particular series. On this particular aspect, Vidika ma'am has earlier uploaded a video that is dealing with an analysis of the number of questions coming from SEBI Grade A Legal Officer Examination in phase 1, phase 2, topic wise. She has carefully discussed each subject and all the topics from which questions have been asked with the number of questions respectively. So if you have not watched that video, do watch it, as it will be helping you out a lot. And then of course these questions are going to be a very good practice for your exam preparation. So do stay tuned to Legal Bee and get in touch with all the videos that are coming up in this series of previous year questions. इस वीडियो में हम लोग लॉ ऑफ कॉन्ट्रैक्ट्स को कवर करने वाले हैं. Let us briefly see the exam pattern that is there for SEBI Grade A examination. You have phase 1. Phase 1 consists of paper 1 and paper 2. For legal paper, you have the second paper that is having a duration of 40 minutes and the cutoff will be 40% in this particular paper. Paper 1 is going to be general for all the streams with a cutoff of 30%. Aggregate cutoff will be 40%. Phase 2 की बात करें तो similar lines पर ही है, सिर्फ इतना ही difference है कि आपका जो English का test होगा that will be in paper 1. To test your drafting skills, it will be in the descriptive manner. Weightage remains same, duration of paper remains same, aggregate cutoff is slightly elevated to 50%. Syllabus, you can check out on phase 1 as well as phase 2 syllabus is available for SEBI. And law of contracts की unit पर हम आज इस वीडियो में फोकस करने वाले हैं. Law of contracts का अगर आप syllabus देखोगे, it is Indian Contract Act chapters 1 to 6 and Specific Relief Act in the phase 1. In phase 2, it is having chapters 8 to 10 in Indian Contract Act, that is the second part of contract, along with Indian Partnership Act added to it and Specific Relief Act तो है ही. The weightage will be 10% in both the phases. So as per the weightage, you can expect around 5 questions. That 5 can become 4 also and it can become 7, 8 as well. But the range you can understand. And अगर आप ये चेकआउट करोगे कि 2020 के पेपर में 2022 के पेपर में कितने क्वेश्चंस आए थे, then it was respectively 7, 8, 8 and 5. So those questions we are going to discuss today in this particular video. पहला क्वेश्चन है, which section covers contingent contract as per the Indian Contract Act? कौन सा क्वेश्चन contingent contracts को डिस्कस करता है? And it is of course a direct question from a very important topic, that is contingent contract, section 31. Section 31 deals and defines contingent contracts. It says that a contingent contract is a contract to do or not to do something if some event collateral to such contract does or does not happen. कई बार आपको सेक्शंस भी याद रखने होते हैं जो बहुत ही इंपॉर्टेंट टॉपिक्स हैं, वहां पर मैं आपको सजेस्ट करूंगी दैट यू शुड remember it. Second question, which of the following is not true about contingent contracts? This is again from contingent contract topic, so you can see how important it is. Contracting parties have interest in the subject matter in a contingent contract. Uncertain events should be collateral. It is a contract to do or not to do something with reference to a collateral event happening or not happening. Contingent contract is always wagering in nature. B and D, that is uncertain event should be collateral along with contingent contract is always wagering in nature. इनमें से कौन सा कंडीशन है जो ट्रू नहीं है, which is false about contingent contract? Don't skip the word not. ऐसे कई बार होता है, स्टूडेंट्स ये सिली मिस्टेक करते हैं और उस क्वेश्चन का पूरा मीनिंग उल्टा हो जाता है. What is not true about contingent contracts? And the answer is contingent contract is always wagering in nature. contingent contracts are having all the above mentioned features about the uncertain event being collateral, जो अभी हमने सेक्शन में ही पढ़ा है, and the subject matter in the contingent contract, for that contracting party should have interest in it, and the collateral event to do or not to do something, this is the simple definition of it. But जो wagering nature वाला point है ये गलत है यहाँ पे. It can be wagering or it cannot be wagering, it depends. Third question, A agrees to pay B 1000 rupees if B marries A's daughter, namely C. C was dead at the time of the agreement. So which type of agreement is this? Wagering agreement, wagering contract, voidable contract, contingent agreement, C and D. That is voidable contract and contingent agreement. So the answer is contingent agreement. Contingent agreements to do or not to do anything, if that impossible event is happening, are void, of course. And if the impossibility of the event is known or not known to the parties of agreement at that time it is made, then Contract Act section 36 deals with this concept of contingent agreement, कि अगर उस समय पर A और B को ये नहीं पता था that whether C will die at that time. So that is coming under the definition of contingent agreement. Which of the following is mode for revocation of a proposal? By the communication of notice of revocation by proposer to the other party, by lapse of time prescribed in that proposal for its acceptance, and if there is no time prescribed, then by lapse of reasonable time but without communication of the acceptance. कई बार इस तरीके से options थोड़े descriptive, थोड़े लंबे हो जाते हैं, तो उसमें हमें काफ़ी tactfully उन्हें solve करना होता है within less time, as the duration you have seen is not that much. By failure of the acceptor to fulfill a condition precedent to the acceptance, or by death or insanity of the proposer, if the fact of his death or insanity has come to the knowledge of the acceptor before the acceptance itself, all of the above. Answer will be all of the above. All these modes are actually the modes of revocation of proposal that are mentioned under section 6 of the Indian Contract Act. An agreement enforceable by law is a contract, and this is discussed under which section of the Indian Contract Act? A very direct question again. This is the definition of contract, which is discussed directly under section 2H of the Indian Contract Act. Which of the following statements about acceptance is false? Mere silence can never amount to acceptance of an offer. Proposal must be accepted within the time limit that is given by the offerer. Proposal must be accepted within a reasonable time. Implied acceptance is not considered as a valid acceptance. None of the above. So इनमें से कौन सा statement false है? They are asking about acceptance. And the answer is implied acceptance is not considered as a valid acceptance. This statement is false, as implied acceptance is considered as a valid acceptance of an offer. So this is the false statement. Section 8 आप इसके लिए refer कर सकते हैं. That is talking about acceptance by conduct or actions of the promisee being acceptable, that amounts to implied acceptance. When an agreement is discovered to be void, or when a contract becomes void, any person who has received any advantage under that agreement or contract is bound by. Now what is the question? An agreement is discovered to be void, or a contract later on becomes void. Any person, if has received any advantage out of that, he will be bound to do what? He will be bound to restore it or make compensation for it from whosoever he has received it. He is not bound to restore it but make compensation. He is bound to restore it but not to make compensation. Neither restore it nor make any compensation. None of the above. Answer is A, that he has to restore it also and he has to give compensation also for it to the person who has given him it. Section 65 Indian Contract Act का इसके बारे में बात करता है. Obligation of a person who has received an advantage under a void agreement or a contract that later on becomes void. सेक्शन 65 यू कैन रेफर फॉर दिस पर्पस. आप इस वीडियो को स्टॉप करके भी आराम से क्वेश्चंस को नोट डाउन कर सकते हो, या फिर इस वीडियो के लिंक डिस्क्रिप्शन लिंक में आपको पीपीटी भी मिल जाएगी. यू कैन टेक इट फॉर योर रेफरेंस. ऑल्सो यू कैन डाउनलोड द मेमोरी बेस्ड पेपर्स ऑफ 2020 and 2022 फॉर प्रैक्टिस. That is there in the description of this video. Coming to next question, Partnership Act. The firm is dissolved by notice of partnership at will from the date of mentioned in the notice as the date of dissolution, from the date mentioned in the notice as the date of dissolution, or if no date is mentioned, from the date of communication of notice, from the date of communication of the notice simply, from the date mentioned in the notice as the date of dissolution, or from the date of communication of the notice. Now they are asking us from which date you have to count actually dissolution of a partnership at will. Notice तो देना ही है उसमें. And if no date is mentioned, from the date of communication of notice as from the date mentioned in the notice. Answer is going to be B, that is from the date mentioned in the notice as the date of dissolution, or if no date is mentioned as the from the date of communication of the notice. अगर नोटिस में स्पेसिफिकली दिया हुआ है कि इस डेट से आपका डिसोल्यूशन काउंट होगा तो उस डेट से होगा, और अगर नोटिस में स्पेसिफिकली नहीं दिया है then the date will be counted from the date of communication of that particular notice. And the provision is section 43 of the Partnership Act, dissolution by notice of partnership at will. The partners in partnership at will have to give a notice mandatorily, that has to be in writing, to all the other partners of his intention to dissolve the firm. So उसके कंटेंट से आपको इन्फर करना होगा कि कब से पार्टनरशिप डिसॉल्व हो सकती है. In order to bind a firm, next question, in order to bind a firm, an act or an instrument done or executed by a partner or other person on behalf of the firm shall be done or executed in the firm name or in any other manner that is expressing or implying an intention to bind the firm. In the firm name only. In any manner that is expressed or implying an intention to bind the firm. In the firm name, but not in any other manner expressing or implying an intention to bind the firm. None of the above. Now, in this situation, the answer will be as per section 22 of Partnership Act 1932. If you refer, in order to bind a firm, an act or instrument that is done or executed by a partner on behalf of the firm shall be executed, of course, in the firm name. And if other than that, in any other manner that is expressing or implying an intention to bind the firm. So that is directly picked up, the statement as it is has been picked up from section 22 of the Partnership Act. Mode of doing an act to bind the firm. If the act has to be binding on the firm, then that act should be done in the firm name or any manner which is expressing or implying an intention to bind the firm. A singer A contracts with B, the manager of a theatre, to sing at his theatre for 2 nights in every week during the next 2 months, and then B engages to pay her 100 rupees for each night's performance. On the 6th night, A willfully absents herself from the theatre, and in consequence B rescinds the contract. ये काफ़ी common illustration है जो contract act से पूछा जाता है. And in this situation, B must not pay anything to A. B must pay A for 5 nights for which she has sung. B must pay A for all the nights under the contract. B must pay for 6 nights. None of the above. And the answer will remain B. B must pay A for 5 nights for which she has been singing. Section 65 of Contract Act deals with obligation of a person who has received an advantage under void contract or contract that becomes void, and if an agreement is discovered to be void or when a contract becomes void, any person who has received any advantage, then he has to make compensation for it and restore it. Illustration C has been picked up directly from this section. As I told you, many times this question is asked. A person entitled to the possession of a specific movable property may recover it in the manner. Now this question has been picked up from Specific Relief Act. And any person who is entitled to possession of specific movable property may recover it in the manner provided by Indian Contract Act, Specific Relief Act, Civil Procedure Code, Transfer of Property Act, Evidence Act. A very easy question, and that can be picked up as per the procedure of Civil Procedure Code. Now in the first instance everybody will pick Specific Relief Act, but now you have to focus that the question is talking about the procedure, and this is how the question is simple, but at the same time it can become confusing. How? Section 7 of Specific Relief Act talks about recovery of specific movable property. It is the substantial part. Substantial powers have been given by this section. But the procedure for recovering that has been given as per the manner provided in Civil Procedure Code 1908. An acceptance may be revoked at any time before the communication of acceptance is complete as against the acceptor. Acceptance is complete as against the proposer but not after that. Acceptance is complete as against the acceptor but not afterwards. Proposal is complete as against the acceptor but not afterwards. Proposal is complete as against the proposer. Answer is C. When the acceptance is complete as against the acceptor but not afterwards. Of course, that acceptance has to be complete against the acceptor. Till that time you have a chance to revoke it. But once it has been complete as against the acceptor also, then that cannot be revoked. Section 5 of Indian Contract Act talks about revocation of proposals and acceptances both. And such kind of question can be asked to you about proposal also. So be very careful about it. अगर proposal का भी कोई question आता है, then proposal may be revoked at any time before communication of its acceptance is complete as against the proposer. And acceptance can be revoked at any time before the communication of the acceptance is complete as against the acceptor and not afterwards. Section 5 covers this. If the pawner makes a default in payment of the debt or performance at the stipulated time of the promise, then in respect of which the goods were pledged, the pawnee may. Now they are talking about when the pawner has made a default in payment of that particular debt or any performance, then in respect of that goods that are pledged to him, pawnee can do what? He can bring a suit against pawner upon the debt or promise, retain the goods that are pledged as a collateral security. He can sell the things that are pledged on giving the pawner a reasonable notice of the sale. He may bring a suit against the pawner upon the debt or promise and retain the goods also as a collateral security, and may bring a suit against the pawner upon the debt or promise, retain the goods as a collateral security, or may sell the things that are pledged. That means all the possible in E clause, all the possible modes have been mentioned. So the answer will remain as E, because all the possible modes have been mentioned in section 176 of Indian Contract Act, that pawnee's right where pawner has made a default. So if pawner has made a default, then pawnee has all these rights in particular. All the options that were there are available to him. You can refer section 176 for that purpose. Now, what is a contract as per Indian Contract Act 1872? Very simple definition. Again, this was repeated other way round. In earlier also we have seen this question. Similarly, it has been repeated, and the definition of contract very simple. Agreement enforceable by law. Section 2H of the Indian Contract Act talks about it, because this will be the most appropriate definition and most appropriate option over here. Substitution of old contract with a new one. Very easy and a very commonly asked question is novation of contract is the answer for it, because it is substituting an old contract with a new one. Section 62 of the Contract Act discusses novation, rescission and alteration of contract. So section 62 is an important section. यहाँ से कोई भी question आपको पूछा जा सकता है. If a party to contract agrees to substitute a new contract for it, rescind it or alter it, then the original contract need not be performed in that condition, and the parties to a contract can agree to substitute a new one for it, rescind it or alter it. Contract made by a person under undue influence is voidable at the option of the party whose consent was obtained in such a manner. Void ab initio, valid subjected to express agreement of the party. Answer is B, as it is voidable at the option of the party whose consent was obtained in such a manner. The consent was not free. Section 19A talks about powers to setting aside a contract induced by undue influence. When the consent to an agreement is caused by undue influence, then the agreement to a contract is voidable at the option of the party whose consent was so caused. Which section of Contract Act defines proposal? Direct question again, and the answer is very easy as it starts with it section 2A से ही proposal से ही start होता है सारे definitions Indian Contract Act में, and section 2A you can refer for that purpose. What is actually a proposal? As per Specific Relief Act, a person dispossessed of an immovable property can file a suit within. Now within how many months, how many years, whatever it can be, as per Specific Relief Act, a person who is dispossessed, he can file a suit for recovery of that immovable property, and the answer is directly 6 months as per section 6 of Specific Relief Act. The answer is 6 months. Within 6 months from the date of dispossession, he has the time limit to file a suit for dispossession, suit for recovery, sorry. Specific relief is granted for specific performance, compensation, damages, both A and B. अब यहाँ पर ऑब्जेक्टिव पे फोकस करना होगा आपको, एक्ट का ऑब्जेक्टिव क्या है, and by putting these two options they have made it more confusing for you. The answer will be A. You have to just focus on what Specific Relief Act is basically talking about. Main thing that specific relief is granting is specific performance, and it is providing an equitable remedy or relief. Exact fulfillment of an obligation is what is the main objective of this particular act. So that's how you have to pick the most appropriate option as per the question. In a suit for specific performance of contract, compensation can be claimed as damages, cannot be claimed, can be claimed but in addition to specific performance of breach of contract, can be claimed in substitution of specific performance for breach of contract, can be either C or D, addition or substitution. So the answer here will be E. As per directly you can refer section 21 for that purpose. It is talking about power to award compensation in certain cases, and it is talking about both the modes, either in addition to the specific performance or it can be in substitution of that performance. That is covered in section 21 clause 1. When a contract has been broken, compensation for any loss or damage that is caused to an aggrieved party shall be given for the loss that naturally arose in the usual course of things. Compensation is not to be given for any remote and indirect loss or damage sustained by reason of the breach. Loss which the parties knew when they made the contract to be likely to result from the breach of it, either A or C, either of the above. Now here they have worded it in, we can feel that they have worded it separately. So very carefully you have to read all the options, that when a contract has been broken, compensation for that loss or damage that is caused, that shall be given for what? So the answer will be D over here. If you refer Contract Act 1872, section 73 is the provision that is talking about compensation for loss or damage that is caused by breach of contract. When a contract has been broken, then the party who suffers by that breach is entitled to receive from the party who has broken the contract any compensation for any loss, damage which naturally arose in the usual course of things, or which the parties knew when they made the contract to be likely to result from the breach. Next question. What are the rights which are available to an indemnity holder as per Indian Contract Act? Indemnity is another important topic. Damages, subrogation, refuse indemnity, all of the above, both A and B, that is damages as well as subrogation. यहाँ पर थोड़ा सा confusion हो सकता है students को rights of indemnity holder and rights of indemnifier में, but if your basic concept is clear, you can solve it within seconds. The answer is A. Damages, section 125 is specifically talking about rights of an indemnity holder. Other rights were actually talking about the indemnifier. But damages is what is available to the indemnity holder. You can refer section 125 for that purpose. A gratuitous bailer is duty bound to. Now they are talking about bailer who is gratuitous. He is having some duty to disclose to the bailee faults in the goods bailed, which bailer is already aware of. To disclose the defects which are immaterial, disclose the faults which may not expose the bailee to extraordinary risks, disclose to the bailee a list of all possible faults which may or may not be present in the goods but can arise in the future. Disclose to the bailee the things that bailee should be careful about. Now, gratuitous bailer is expected to do what out of all these 5 options? He has to disclose what? Answer is of course A. If you don't know the particular answer, the section provision for this, even if you read the options carefully, you can easily guess that the most appropriate one will be A only, because the other ones are not logically fit options over here. Section 150 talks about bailer's duty to disclose faults in the goods that are bailed. So bailer is bound to disclose to the bailee all the faults in the goods that are bailed, of which the bailer is aware, of course. And gratuitous bailer is also going to come under that category only. There is no separate category of duties for gratuitous bailer. If it is materially interfering with any of the with the use of that particular good, or it is exposing the bailee to extraordinary risks, but in the options it was given other way around for this. So if you carefully read it, you can easily answer it. If a partner commits wrongful acts within the course of business of the firm, who will be liable for that? Entire firm, partner only, designated partners, both B and C, that is all the partners along with designated partners, or only those partners who have in any way contributed to that particular wrong and have benefited from that wrongful gain. Now this can be a bit confusing for some people who are not conceptually clear in this particular act. Answer is A. Entire firm will be liable if the act is done within the course of that particular business of the firm. Then entire firm will be liable for it. No chance of getting confused over here. Section 26 of Indian Contract Act directly discusses it. This is talking about the vicarious liability in case of partnership firms also. The person who is a partner is actually an agent of the firm. This concept should be very clear in your mind, that partner is an agent of the firm also. Even if he is an agent of other partners, he is an agent of the firm. Section 26 and 27 covers this vicarious liability concept. Now the last question. Which of the following is true about a minor's liability in a partnership firm? Another important area. Minor shall be personally liable. Minor shall not be liable personally, nor his shares will be liable for the acts of the firm. He shall not be liable personally, but his shares shall be liable for the acts of the firm. Minor shall not be liable after majority as well. Minor shall not be liable for all acts of the firm that are done before his attaining majority. Now you can see the question, the options have been designed very beautifully. So be very careful and answer the question which is most appropriate. So here personal liability of course cannot arise, but his share will be liable for acts of the firm. This will be the most appropriate answer over here. And section 30 of Indian Partnership Act is talking about minors are admitted to the benefits of a partnership. It is specifically talking about that minors can get the benefit of partnership firm they can be admitted to the benefits of the partnership, but personal liability will not come to them. उनका जो शेयर होगा उसमें से जो भी liability है उसको पे किया जाएगा, but they won't be personally liable for that. So you can go through this section. It is another very important provision from Indian Partnership Act. So this was all about the set of questions that I had to share from you from 2020 and 2022 previous year papers for SEBI Grade A Legal Officer Examination. You can go to the link and immediately download these two papers and have a look at all the questions, not only contract but बाकी सारे questions को refer करो. And एक बार अगर वो आपकी आंखों के नीचे से जाते हैं तो आपका काफ़ी सारी analysis और clarity आपको आ जाएगा. Try to solve these questions. For more help, you have Legal B, your one-stop solution for all legal exam preparation at iExamB. Legal B is a channel for it. We also come up with videos regularly, not only for SEBI but also for other examinations, banking law officers. We have courses available. We have courses available for legal officer in various bodies. So you can refer to our website and check out how iExamB helps you in making it 50% faster. Thank you so much.